All right, Mr. Cox, I do remember vividly when I sentenced you, and I did tell you that I would consider judicial release. So at this time, I'm going to honor that and indicate that I'm going to suspend further execution of the. This is case number 25CR42737, the State of Ohio versus Eric Cox. Mr. Cox is before the court with his counsel, Mr. Perry. Ms. Tranter, on behalf of the State of Ohio, we are here for sentences. Tranter, anything on behalf of the state?
Yes, Your Honor. On behalf of the state, we are asking that this court impose a prison term upon Mr. Cox. I do believe that this is a serious safety. It's his 7th overall driving under the influence. My understanding is that he has 13 days of jail time credit, and this is a situation where I would be also asking for a lifetime driver's license suspension. Mr. Cox has proven that he has no regard. He was driving under an OVI suspension when he picked this one up. So I do believe that a lifetime ban on him driving is appropriate, and we would ask for an appropriate prison sentence as well.
Okay, anything from probation?
The recommendation from probation is prison with potential judicial release, Your Honor.
Okay. Mr. Perry.
Judge, as strange as this is, we recognize that the court is going to punish Eric today. We recognize that it is very likely that he'll go to prison. But if he had his choice of local jail time, a CBCF, or DOC, he would actually ask the court for DOC so he can continue his bipolar medicine, which is lithium. And I'll also say this, Judge, I guess I'd ask the court to temper any punishment that is imposed today based on this. I can't stress the importance of this diagnosis in June, where at Recovery Refined, they actually realized that for the last 25 years he's been treated for depression, chronic depression, with antidepressant medicines that have only aggravated a bipolar disorder that was never diagnosed until the summer. So moving forward from this offense, the hope is, the expectation is, that this newfound diagnosis and his treatment with lithium may very well change how he responds in the future. We have very high expectations that these hypomanic episodes that often lead to Eric believing he can do things that he cannot do, but he still engages in that risky behavior. The hope is with this medicine, the lithium, those highs will disappear, and he will be the person he's always tried to be. Absolutely 100% compliant in the medications that the doctors suggest that he takes, and absolutely positively compliant with his recovery, because he knows full well that he is an alcoholic, and if he begins to use, he's only going to abuse the alcohol until he goes out into such a highly alcoholic rage, crazy things happen. So again, Judge, we realize what the court is about to do. We ask for some level of mercy, some temperament, some ability to temper the sentence, so that this expectation for his future can be realized sooner than later. He is supported this afternoon by his mother, by his fiancée. He is a business owner, a very successful painting business. These are things that he does not want to lose. He realizes he has a debt to pay, but he certainly would like to come out of the DOC sooner than later.
Mr. Cox, is there anything you'd like to say before I sentence you, sir?
Just simply that I'm sorry. I am really sorry, and I give account, and I'm ready to, serve my sentence as a man. I realize that I do deserve to be punished. I realize that Ed's told me before, they keep saying that they've given him kind of light sentences, and I've said, Ed, I don't disagree. And so I know that you're going to be a little bit more harsher, and I just want you to know that I accept that, and I deserve that. I do say also with that is, I'm sorry. I'm sorry that I've put you guys in this position. This is not the person that I want to be, or the person that I am. And then with that, I think one thing that gives me a sense of hope is I do have some understanding of something else that's going on that may be contributing to this that I can now address, so this doesn't happen anymore. Because I don't want to behave like this. I don't want to hurt someone. Like, that's not me. And so, I'm sorry, and I'm ready to pay the price. That's it.
All right, court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Cox, I get that there's a mental health component to this, and I'm certainly not, I am certainly compassionate to the situation you find yourself in. And again, I don't intend to throw the book at you. I've told Mr. Perry that with having seventh OVI, with you being on probation at this time for the offense of OVI, when having committed this offense, having a high tier test above a .17, it's very, very concerning to me. And you go back and look at all your prior sentences, and you've always received the maximum mandatory penalty, which again, as an attorney, that's what you did to represent. But as a judge, as I sit here now, I do have to account for my decisions as well. I do appreciate the fact that you're accepting responsibility, that you're accepting your punishment. But again, my hope is that we get your attention to the point where we don't have this ever happen to you again. Or even worse, if for some reason that you would do it and hurt somebody. I mean, that would be, can you imagine how you would feel if you had hurt somebody in this?
I'm gonna be able to live with myself, Your Honor.
So what I'm gonna do is, on the OVI charge, I'm gonna order you to serve 24 months in prison. You have 13 days jail time credit. I am suspending your operator's license for your lifetime. There is a fine of $1,370, which I do not have the authority to waive. Other than that, I am going to find that you're indigent for the purpose of fines, costs, or other financial sanctions, other than that mandatory fine. And I did tell you, I told Mr. Perry, that it is my intention that I would grant you judicial release after you serve a portion of your sentence. Of course, there's a mandatory portion of this sentence that you have to serve, which is 120 days.
I think it's 122.
120.
120, so that you have to serve at least that long. But after that, I would be open to considering you for judicial release, and hopefully will have gotten your attention at that point in time. Does that make sense?
That makes sense, Your Honor.
All right. Again, I don't try to be harsh. I try to be realistic. I just was looking at something and.
Yeah, and again, I understand.
Okay.
I understand the predicament you're in.
Okay, so you are subject to a discretionary period of post-release control. So, and I'm required to tell you this. So, if you serve out your sentence, when you are released, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, all of that can be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
Your Honor, you said the fine is $1,350?
I said 1,350, yes.
Okay,
Did I
thank
say
you.
something different than that?
I thought you said 70, and I may have misheard you.
I
but
did
it's-
say 70, because that's what I wrote down, but it's 3,350.
Correct.
Mr. Perry, is there anything else?
Nothing for the judge.
All right, this time, Mr. Cox, there is a deputy standing behind you. I am going to remand you into the custody of the Warren County Sheriff for transport to the Department of Corrections.
Touch palms together just like a friend. Touch it together just like.
Oh, like that, sorry.
CR 42737, the State of Ohio versus Eric Cox. Mr. Cox is before the court with his counsel, Mr. Perry, Ms. Tranter, on behalf of the State of Ohio. We are here on the defendant's motion for judicial release. Does the state have a position? Anything from probation?
Nothing further, Your Honor.
Mr. Perry, you wish to be heard.
Judge, we would submit the previously filed pleadings and prior arguments.
All right. Mr. Cox, is there anything you want me to know?
Just that I'm sorry, I'm very, that I'm here, for my behavior that led to this. I'm grateful for the opportunity to come back and for you to consider the motion of judicial release. I just want you to know that I am super determined to never let anything like this happen again. I don't wanna let my mom down, I don't wanna let my fiance down. I've got a business on the line, like this has been a nightmare. I've learned from it a lot, and I've learned a lot about myself. I guess one good thing is the diagnosis of bipolar to describe and explain what's been unexplainable. I take that very serious and being compliant with my medication and just making sure that I have a stable platform where I can work a program of recovery, where I can make my faith a priority, where I can live a productive, good life and not have to put myself in a situation like this again or others in harm. That's it, Your Honor.
All right, Mr. Cox, I do remember vividly when I sentenced you, and I did tell you that I would consider judicial release. So at this time, I'm going to honor that and indicate that I'm going to suspend further execution of the prison sentence and grant your motion, place you into community control for a period of 3 years. Now, you'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand that?
Yes, sir.
Okay. I'm going to order an updated assessment because the assessment that we have is back in November of 2025. Since you've been, hopefully, been abstinent over the past 6 months.
Yes, Your Honor.
I'll assume that you have. I'm going to update the assessment, including that mental health component. You are ordered to comply with that, any recommendations from that assessment. You'll be placed on a TAD monitor when you are released from the jail. I'm going to get released today. I apologize, folks, but I want to get this assessment completed because it'll be done fairly quickly, a day or so. Okay, is that right, officer?
Yes, Your Honor.
Okay, thank you. As previously, would you give me an updated jail and prison time credit for me?
Prison time credit is 170 days, jail time credit is 13.
All right, so sound about right?
I
Who's
think-
counting, right?
Yeah.
All right, so we'll update those for your record. Remember, your operator's license is currently suspended for your lifetime, so you have no driving privileges. Do you understand that?
Yes, Your Honor.
All right. There was previously a mandatory fine of $1,350, which I do not have the authority to waive, so that, again, will have to be paid to the bureau, to the court. Let's see. I'm also going to place you on a TAD monitor, is an alcohol monitor, and I'm going to leave that. Did you say, Abby, you were
He would go to Officer Sukavecki.
Sukavecki, so I'm leaving that to her discretion for how long that stays on. Generally, once she gets settled in and she can see that you're engaging in treatment, I will leave that to her discretion, okay?
Okay.
Ms. Tranter, is there anything else I left out?
No, sir, thank you.
Mr. Perry?
Nothing, Judge, thank you.
All right, Mr. Cox, let's get this right, okay, sir?
Okay, thank you.
Good luck to you.